Students, I am Anubhav Sharma and I will be a faculty for Indian Polity. And in this module, we will be covering historical evolution of Indian Constitution. Now, students, what I've essentially done is to break it down into two modules, that is module number 4 and 5 will deal with historical evolution of Indian Constitution. What exactly will we be studying in this? Essentially, what we are studying is how exactly our constitution came out to be what exactly it is today. We need to know some aspects of the various stages in which the constitution got developed, not just in after what Constituent Assembly did, but also with respect to how provisions that we see today got developed. As such, both historical evolution 1, that is in module 4, and module 5 will be very, very important for you for this examination. Now, another point to note here is that while in modern history you must have studied about this, I am again taking it here because it is also important for your polity part. So when you study modern history, you would need to study it, and when you study for polity, you again would need to study it. But with respect to polity, the idea is to give emphasis only to some of the important acts that was made by the Britishers, because those were the acts from which the questions are getting asked, and those were the acts from which maximum provisions have been borrowed and carried forward into the Constitution of India. Keeping that in mind, these two modules have been designed. Keeping that in mind, let's go ahead with the first topic of the day, and that is Regulating Act of 1773. Now, students, we know and we have studied it in modern history that in 1765, what happened? In 1765, what happened was that the company, that is East India Company, was able to obtain Diwani rights, that is right over revenue and civil administration for Bengal, Bihar, and Orissa. So essentially, after Battle of Buxar in 1765, the company decided that they would need to do something with which they are able to have a better control over the administration in India, because they knew India is going to be a golden goose for them. As such, in 1765, they were able to procure Diwani rights, which meant they could take revenue from the land and they could also administer civil justice system within the land, right? What exactly were the provinces where they were administering this? They had the Diwani rights of Bengal region, Bihar region, and Orissa region. A very important point that we need to keep in mind. What exactly was the idea? The idea was pretty simple, that now we would need to take very measured steps towards territorial expansion in India. India is one country that we would want to expand into for the reason that India is a very rich source of raw material. Now, students, if you remember, this was the time when industrial revolution was also happening. The factories had a lot of machines and their capacity to produce was a lot higher, in fact, highest than ever before. As such, what they were looking for was raw material. India was one country which could provide them raw materials of all nature. In fact, in future, India also became a market where they could sell the finished product that their companies were making to the Indians, right? Thus, it became necessary on the part of British government to make sure that they are able to take those steps by which they could regulate the activities of the company over there. Keeping that in mind, it was decided after about 8 years of Diwani rights being procured by the East India Company to pass an act called Regulating Act of 1773. So an act, that is Regulating Act of 1773, was passed by British government. Why exactly was it passed? Because they wanted to regulate the affairs of East India Company operating in India. Why exactly was there a need to regulate it? For the reason India increasingly was becoming a very important economic factor in the administration of the empire of British, right? I hope this point is clear. Now, the other important thing is to understand the features of these acts. What all were the features of Regulating Act of 1773? The first very important feature was the fact that now Governor of Bengal will be called as Governor General of Bengal. Why exactly has he been made Governor General of Bengal? The reason was very simple, because they wanted one person, one governor to be in charge of other governors. They knew that Bengal is the most precious possession in India of British Empire because of various factors. As such, the person who will be handling the administration of Bengal, the governor who is in charge of Bengal, will now be made Governor General of Bengal. And the idea is the other governors will now report to this Governor General of Bengal, right? So the first Governor General of such a nature, that is Governor General of Bengal, was Lord Warren Hastings. Lord Warren Hastings was the first Governor General of Bengal, and this is a point which is important both for your prelims as well as for your PCS examinations, right? Governors of Bombay and Madras presidencies were made his subordinate. As I just explained, the whole idea was there has to be a kind of system by which administration can happen. And this idea was that it will be the governor of Bengal who will now be called Governor General of Bengal, to whom both governors of Bombay and Madras presidencies will report to. They will be their subordinates. The Act provided for establishment of Supreme Court 1774. This again is very, very important for us to remember. Students, the whole idea of regulating Act of 1773 on the part of British government was not just they wanted to have economic benefits keep coming from India, but they also wanted to establish their empire, their administration. A very important component of it is to establish judiciary, that is a justice administration system. Now, any justice administration system cannot be established without an apex body. Thus, there was a need to establish Supreme Court. The first Supreme Court thus got established in 1774 in Calcutta. This again is a question, a statement that has been asked in UPSC prelims exam. As such, it is very important, and please make a note of it. Servants of the company were prohibited from engaging any private trade. This again is an important provision. Again, something that has been asked in UPSC prelims. What exactly does it mean? Essentially, before 1773, there were employees who were working for East India Company. These employees had a duty that they had to deliver upon with respect to the job they have. But at the same time, there was nothing barring these employees to engage in private activities, private economic activities, private trade, so on and so forth. Thus, it was realized that there is a kind of conflict of interest that is happening. As such, it was prohibited that whosoever from the company is working for the company in India will be barred from engaging in any kind of private trade. Thus, there would be no issue of conflict of interest as such. I hope this point is also clear. The Act told governing body of the company, that is Court of Directors, to report all its affairs to British government. Again, what happened? So essentially, there was a body called Court of Directors. You will study about that in detail when you would study the modern history module. This Court of Directors were the people who were calling the shots on what should be the steps that company should take, what all should be the decisions that the company should take. It was decided that this Court of Directors would now need to report all its affairs to the British Crown, that is the government of Britain. The idea was to have better control over their activities. Thus, Regulating Act of 1773, what exactly did it say? It said that now these court of directors can be summoned in order to provide the reports on their revenue decisions, on their civil military administration, on every aspect of their engagement in India. British government could have a report from them. I hope this point is also clear. So, what all things have do we see happening in Regulating Act? The first thing that happened was now the Governor General of Bengal is the highest authority. That is, the Governor of Bengal has been made into Governor General of Bengal. Governor of Bombay and Governor of Madras would need to report to Governor General of Bengal. We have also studied that Lord Warren Hastings was the first Governor General of Bengal, a very important point. We also studied that it was this act which provided for establishment of Supreme Court in 1774. The reason was because they wanted to establish a justice delivery system. We have also studied that servants of the company were now prohibited. They were barred from taking any private trade or engaging in any kind of private economic activity while in capacity of being an officer of the East India Company. And finally, Court of Directors, the body that used to run East India Company, will now have to uh, uh, present all its reports to the British government so that British government is able to have a better control on Court of Directors. These all things are important that we need to know with respect to Regulating Act of 1773. This brings us to Pitt's India Act of 1784. What is Pitt's India Act? That in Pitt's India Act, East India Company Act of 1784, this is a second name which is being given to Pitt's India Act. It was passed by British Parliament to rectify some of the defects of the Regulating Act of 1773. The whole idea was that now that it's been 11 years since we have passed 1773, we have some experience with respect to everything that has happened, and there could be certain modifications that could be made in order to make the efficiency, in order to make the effectiveness of the company operating in India better, right? So what exactly Pitt's India Act did? It resulted in dual control or joint government in India. What it did was that now it wouldn't just be the company which will be controlling the affairs within India. It will be a combination of two governing bodies. First will be the Crown in Great Britain, that is, in fact, the government of British, and second will be the British East India Company. So now, till 1784, what used to happen? British East India Company used to operate. This court of directors used to report all its functioning to the British government. Now, by Pitt's India Act of 1784, what government of Britain has done is that it has taken some of the powers of administration in India from East India Company, and now there will be two bodies which are administering policies of the company, policies of the British government in India. These two bodies are first the Crown in Great Britain and second British East India Company. I hope this point is also clear. With this act, East India Company's political functions were differentiated from its commercial activities for the first time. Essentially, what was realized was that at the end of the day, East India Company is a commercial body. It's a body which actually went to India for its commercial interest. It wanted to do business, it wanted to gain profit, and that was the end of it. What they have now started engaging in is the administration part, it's the governance part. They are not very competent to do that. So what is required is for us to differentiate the functions which is being performed by East India Company in India into two categories. What all are these two categories? First will be the political functions, while the second will be the commercial functions. The whole idea is that we need to dilute their powers with respect to political functions while give them autonomy with respect to commercial activities. That in fact was the original idea behind East India Company. I hope this point is getting clear that in Pitt's India Act 1784, the first attempt by the British government was made in order to differentiate the functions of the East India Company. They were differentiated into two categories. The first was the political functions, while the second was commercial activities. This point is again very important for your prelims exam. The relationship between company and crown established by this act kept changing over the time till 1858. So in 1858, what had happened? Because in 1857, a revolt had happened, Sepoy Mutiny had happened, First War of India's independence had happened. There were drastic changes that were brought in 1858. But the crux till 1858 remained to be Pitt's India Act that we would see in the course of this lecture. Now, what all were the provisions which were brought about by Pitt's India Act? The first very important provision was establishment of Board of Control. Now, students, I have just explained you that in Pitt's India Act, the idea was to separate the functions into two categories. Functions of East India Company. First was political functions and second was commercial functions. Now, with respect to political functions, the idea was it will be handled by the British government. Now, which department will be handling the political functions of East India Company or administration in India? Thus, a body was required, a department was required. This department was called Board of Control. I hope this point is clear as to what exactly do we mean by Board of Control. A body that was made by British government in order to handle the political functions of the crown in India in possessions that the crown had in India, right? In political matters, company was still now working as somewhat sovereign. The Pitt India Act made the company directly subordinate to British government because now the political functions are being done by British government. The political functions, the political duties will take precedence over the economic activities, if at all. policies pertaining to economic activities will be more dependent on the political activities and the policies that are being made by British government. Thus, the power of the company was curtailed. I hope this point is clear. For the purpose of joint government, a board of commissioners for the affairs of India called Board of Control was created. So, Board of Control was created. What exactly is Board of Control? A board of commissioners for the affairs for India. That with respect to affairs of India, this board of commissioners will take a call on the political functioning. The board was made of 6 people. So what was the composition of this board? Chancellor of the Exchequer, Secretary of State, 4 privy councillors nominated by the king. So this was the composition of Board of Control. Now, in my opinion, to remember this composition is not very important, but still you never know with respect to prelims exam. So just read it couple of times, and at least with respect to the prelims exam, by looking at the options, you will be able to kind of get to the conclusion whether this is statement is right or wrong. Thus, just go through it, just read it a multiple of times, and then you'll actually be able to solve any questions on this. Then we come to the Secretary of State, and the Secretary of State was entitled as the President of Board of Control. So, who was the Board of Control's president? It was the Secretary of State. This board of control was empowered to control all matters of civil and military government or revenues. So, all matters with respect to civil matters, that is, civil administration, military administration, where exactly the army should attack, what exactly should be the composition of army, how to maintain the army, so on and so forth. All those decisions will now be taken by board of control. So, you see that aspect, that is, military aspect and civic administration aspect of the functioning of the company is now being subsumed by board of control. Board was given full access to the company's record. It had powers to send governors to India and give them full authority to alter them. Thus, in dual control, company was to be represented by the court of directors and crown was represented by board of control. So let us again go through board of control so that we have absolute clarity on it. The idea during the time of Pitt's India Act in 1784 was to make sure that the functioning of the company could be differentiated into 2 categories. One was political, second was commercial. They wanted that as far as possible, the political functioning should be taken away from the company and it should be enrolled to a different body directly managed by British government. This body was Board of Control. This Board of Control would now be in charge of all the affairs with respect to military administration, civic administration that is being done in India. This was the composition of Board of Control, right? The Secretary of the State was the President of Board of Control. Again, a point that is clear. In the dual control, what exactly do we see? That company was represented by court of directors. As I explained, court of directors were those people who were controlling the affairs of the company. That is, they were the people who were calling the shots. And then the crown was represented by a board of control. This is how Pitt India Act created a dual government that will now be controlling the affairs in India. Now there were other set of changes that were also done by Pitt India Act. Now that was with respect to Governor General's Council. Now, we know that Governor General's Council, as far as 1773 Act was concerned, will consist of 4 people. These 4 people will form the Executive Council of Governors General of Bengal. This Executive Council will take call with respect to the legislations, with respect to the executive policies. Whenever there is a tie between the members, it will be the Governor General who will have the casting vote. That is, it will be the Governor General who will break the tie. It was felt that it is necessary that we must be able to increase the influence of Governor General with respect to such matters, that is, influence of Governor General on executive policy decisions. Thus, it was felt that essentially we need to have a system where there are only 3 members in Executive Council of the Governor General. If Governor General wants anything to get passed, all he needs is to get one person among the 3 members of the Governor General's Council, Executive Council, to be on his side, and that executive order can be passed. I hope you are able to understand the logic behind it. The logic is very simple, that they want Governor General to have a greater say in the executive policy. In the previous model of 4 members in the Executive Council, Governor General had only casting vote, but now Governor General can actually pass executive policy if he is able to get one among the three members in the Executive Council to take his side. I hope this point is clear. Governor General Council will now have three members, one of whom was to be the Commander-in-Chief of King's Army in India. So one of the members of the three members will be Commander-in-Chief of King's Army in India. This Commander-in-Chief is like the General of the Army. This process of reducing number of members from 4 to 3 was to strengthen the position of Governor General, a point which I just explained. The whole idea is we want Governor General to be able to get any resolution passed even with the help of one member in his side, right? The Governor General Council was now under indirect control of British government through Board of Control. So Governor General Council, the three-member body, will now be under indirect control of Board of Control because they are dealing with executive policy making and legislative policy making. I hope this point is also clear. Now students, this brings us to Charter Act of 1833. Before we start with Charters Act of 1833, let me first tell you there were two Charter Acts preceding it. There was a Charter Act in 1793, and 20 years post that, in 1813, there was another Charter Act. And then in 1833, that is 20 years after 1813, there was another Charter Act. Essentially, the whole idea was that after every 20 years, a Charter Act would be passed by the British government, and that Charter Act would just bring those reforms that is being felt in last 20 years that could increase the effectiveness of British government in India. I hope you are able to understand what exactly was the logic of having 20 years gap between two Charter Acts. The logic was to make sure that the system is bringing about those reforms which are being felt necessary in these 20 years. Why exactly have I covered? I haven't covered 1793 and 1813 Charter Acts because as far as our polity is concerned, these two acts are not that important. 1793 Charter Act and 1813 Charter Act both will actually get covered when we will study modern history. I hope this point is clear. So please do not worry about these two acts. Now, let's come back to Charter Act of 1833. What all were the key provisions which were brought? The first was it was the end of East India Company as a commercial body. So essentially, what do we see? That in Pitt's India Act, the functioning of East India Company was then limited only to commercial body. Now, by Charter Act in 1833, even that function has been taken away from the East India Company. That now you cannot even make calls, you cannot even take decisions with respect to commercial policies in India. The British government had done a careful assessment of the functioning of the company, and Charter Act was renewed after every 20 years, right? But it ended the activities of the company as a commercial body and it was purely made as an administrative body. Now, what exactly is the difference? The difference is very simple, that now the company will not be acting as a body which can take decisions on commercial policies. All they can do is to follow the decisions which the Board of Control has taken and implemented. Let me again explain it so that there is absolute clarity. Before 1833, the company was operating as the body in charge of commercial policies. The company could make commercial policies and company would implement commercial policies. In 1833, it was felt that even with respect to decision making, responsibility of the company that has to be taken away. Thus, now the company was mere a body that would implement the policies made by the Board of Control with respect to economic policies. I hope this point is also clear that now decision making powers, policy making powers of the company has been taken away with respect to commercial activities. They are now purely an administrative body. This brings us to the second important provision. India is now a British colony. What exactly do we mean by that? That this Charter Act of 1833, what it did was to legalize British colonization in India, and the territorial possessions of the company were allowed to remain under its control. But now they were held in trust for of His Majesty. What exactly do we mean by that? It means that now all the territorial possessions will be the colonies of British government. So far, it was under the control of East India Company. There was board of control who were managing the political affairs, but it was still not recognized as colonies under British government, under the crown. After Charter Act 1833, it was made explicitly clear that these possessions of the British in India will be colonies of India, and this has been legalized by this act, that they are colonization of India and territorial possessions of the company were allowed to remain under its control. They will be held under the trust of majesty, that it is under the name of crown every activity now will be conducted in the colony of India, the colony of Britishers in India. I hope this point is clear. Governor General of India, this again is a very important point that we need to keep in mind, because this is a point which has been asked in several PCS exams and it has been asked on a number of occasions, even in prelims exams of UPSC. What exactly does this point say? This point says that now Governor General of Bengal will be called as Governor General of India. What exactly are we trying to say here? Essentially, what we are trying to say here is that now British government believes the possession that they have in India amounts to a substantial portion. Thus, the person who is operating in India will be called, needs to be called at least, as the Governor General of India and not of a province. Secondly, the fact that Governor General of Bengal was the head of the other governors of other provinces, it always used to create a kind of confusion in the line of authority, because these governors used to believe that they are in charge of their provinces. They just need to report to Governor General of Bengal as he is first among the equal. But the idea from the beginning was that Governor General of Bengal is the head of the other provinces of the other governors. In order to eradicate this confusion, this change was made that Governor General of Bengal will now be called as Governor General of India. I hope the logic behind changing the name from Governor General of Bengal to Governor General of India is now clear. This act made Governor General of Bengal the Governor General of British India. All financial and administrative powers were centralized in the hands of governor. All the powers were given to this Governor General in Council. Thus, the Charter Act of 1833 had made Lord William Bentinck to be the first Governor General of British India. This again is where people get confused. Lord William Bentinck was the first Governor General of India and not the first Governor General of Bengal. The first Governor General of India is Lord William Bentinck, and this is where students get confused between names, between governors. So this again is something that I've highlighted, and please keep it in mind, right? There was again an induction of another member in the Governor General's Council, the fourth member. What exactly have we studied? That first, initially, when the executive council was made, there were four members. Then one of the members was removed. Now this executive council became a three-member body. Then in Charter Act of 1833, what exactly do we see? What we see is that a fourth member was again added, but then the idea was not for this fourth member to have a lot of power, but he was in fact a person who was expert in law to advise Governor General of India on legal issues. Why exactly was there a need to bring in the fourth member? The need was because it was felt that now that we are making it to be a colony under the possession of British Empire, it is no longer a territory which was under the control of East India Company. We would need a kind of a convergence as to all the legal provisions that are in operation in British India and with that of in the Britain, right? In London, how exactly things are operating, what exactly is the legal framework. The same legal maxim should be practiced while taking policy decisions in British colony in India. In order to ensure that Governor General is taking decisions, keeping that in mind, he would need the help, assistance of a legal expert. As such, it was felt that with respect to Executive Council, we would include one more member. This member will be a legal expert and he would advise Executive Council and also Governor General of India as to how he should be taking decisions which is in legal conformity to the legal framework in Great Britain. I hope you are able to see the logic behind having the fourth member. It was not to again curtail the power of Governor General of India. It was felt that we need to make sure that Governor General of India is empowered enough to take decisions, but we would want him to have a kind of legal advice, right? The number of members of the Governor General Council was again fixed to four. However, certain limits were imposed on this fourth member. What exactly were the limits? This fourth member was not entitled to act as a member of the council except for legislative purposes. Only with respect to legislative purposes, he would be giving his advice, rendering his advice to the Governor General of India, so that he is in legal conformity to the framework that is being practiced in Great Britain. Another important point to note here is that the power of Governor General was increased drastically. In fact, this charter is called to be the first step taken by British India towards centralization of British India. Why? For the reason that all legislative powers was now concentrated to the office of Governor General of India. So the Governor General could repeal, amend, or alter any laws or any regulations with respect to all persons, all places and things in every part of British territory in India, and all servants of the company and articles of war. Essentially, before this, what exactly used to happen? There were other provinces that were under the control. There were other governors. With respect to those governors could take certain executive decisions and legislative policies within their own presidencies, right? What Charter Act 1833 did was to take away legislative powers of all other provinces and bring it under the control of one authority, that is Governor General of India. That again made it necessary that we need to change the name from Governor General of Bengal to Governor General of India, because all legislative powers, all legislative functions will now be performed by this office with the help of Executive Member Council, right? However, Court of Directors acting under the Board of Control could veto any laws made by Governor General in Council. So while the Charter Act brought about a change where Court of Directors will now be given the privilege of taking shots on economic policies, commercial policies, it was also felt that Court of Directors should be given some kind of power so that they feel that they have a stake in decision making, and that was done via giving them some veto powers with respect to some of the decisions which Board of Control can take. Let me give you an example of that. In Charter Act of 1833, one of the decisions that was taken was that the competitive exams in India will be made to open to all. That is, all people can actually be can participate in the competitive exam that is being conducted. Even the Indians could participate in it. The natives could also participate. Court of Directors had actually vetoed this aspect of the bill, and they said that they are not okay with having Indians to be who are handling the positions of officers in the company, and thus this aspect of the Charter Act of 1833 was removed. Another very important reason why Charter Act of 1833 is important is because it was the first step towards codifying the laws. What exactly do we mean by codifying the laws? It's not that before 1833 there weren't any laws that were present, but those laws were not codified. By codification, what happens is that the stretch of interpretation can get limited only to the literal interpretation. That is, whenever you're codifying a law, what you have essentially done is to explicitly explain what exactly is the content of law. So whosoever seeks to implement it would need to come good on the letter of the law. What it does is that it totally removes the confusion to a great extent, because if there is no codification, a person can actually interpret the essence of law to the way of his liking, and thus there wouldn't be any kind of uniformity in the implementation of law. As such, it was felt necessary that even with respect to the British colony in India, they would want codification of laws to happen, and Charter Act of 1833 in that regard is again very important. And this again could be a question that can be asked, that under which act of British Parliament or British government codification of law in India started for the first time, and the answer of course is Charter Act of 1833. British Parliament as a supreme body retained the right to legislate for the British territories in India. All laws made in India were to be laid before British Parliament. So all the laws that are being made by the Executive Council, or for that matter, any kind of law that is being made, that has to be laid before British Parliament for its approval. British Parliament in itself can also pass those laws which needs to be implemented by the Governor General in India because it has been passed by the British Parliament. Thus, what exactly do we see? That what we see is because there was an attempt to codify the laws, there was also a need towards establishing India's first Indian Law Commission. So, India's first Indian Law Commission got established in 1833. This again becomes very important. Why? Because this could be a question in prelims exam, that India's first law commission was established under which act of British Parliament? Answer again is Charter Act of 1833. Who exactly was the person who was heading it? It was Lord Macaulay. In fact, students, many of the writings of Lord Macaulay is very, very insightful. If you have some spare time, please do look into it. It's very insightful with respect to understanding how bureaucracy works, how administration works, what exactly is the responsibility of a government, so on and so forth. Anyways, coming back to our lecture, the objective of the Law Commission was to inquire into the jurisdiction, powers, rules of Court of Justice, police establishment, existing forms of judicial procedure, and nature and operation of all kinds of laws. So, what exactly will be the function of Law Commission? The first, of course, is to codify law. The second is to understand and define the jurisdiction of different bodies. What all can be the bodies? What exactly are the powers and jurisdiction of police authority? What exactly are the powers and jurisdiction of Supreme Court? Where exactly Supreme Court can interfere? Where exactly Supreme Court cannot interfere? If there is military administration, is there a need for separate kind of law for them? All those questions needed to be answered, and it was the duty of the first Law Commission under the able leadership of Lord Macaulay to find those answers and give it to the British Parliament. It was directed that Law Commission shall submit its report to the Governor General in Council, and this report was to be placed in British Parliament. This brings us to the final Charter Act. This again is very important. The reason why I call it to be final Charter Act is not because after it there weren't any Charter Act. This is very important because it was the last Charter Act before 1857 mutiny. So this was the last of the series of charter acts passed by British government between 1793 and 1853. As I explained, that from 1793 onwards, after every 20 years, there was a charter act which was being made. After 1833 act that we just discussed, this was the second act which came about, that is 1853 act. Features of this act: it separated for the first time legislative and executive functioning of the Governor General's Council. This is something that we call as separation of power. It was felt that Governors General's Council essentially is handling both functions, that is legislative policy making, and executive functions, that is implementation of the policies, making executive policies, that is what all policies are required in order to implement the legislations that has been passed. It was felt that what essentially it does is it is making a lot of powers to rest in few hands. As such, the idea of separation of power was brought for the first time. 6 new members called legislative councillor were added to the council. This again is very important. These 6 new members are now legislative councils. These are the members who will legislate the policies. Another point to note here is that of the 6 new members in the legislative councillors, 4 of them were actually appointed by the governors of the different provinces. Thus, what exactly do we see? That with respect to the legislative council of the governor, there will be 6 members, out of which 4 is being sent by the other governors operating in other provinces of the British territories, and thus they are able to ensure kind of local representation in the legislations that are being passed. A very similar kind of an example, though not exactly the same, is Rajya Sabha. What exactly is Rajya Sabha? It is the upper house of parliament. How exactly people or members in Rajya Sabha getting appointed? They are appointed, they are elected by indirect elections, that these elections happen in the different state legislative assemblies. The idea is that in Rajya Sabha, the decisions that parliament is taking, Rajya Sabha will act as representation of the state governments across India. Something of similar sort was done at that time, where the governor would actually appoint the governor of the different provinces would appoint their legislative member who would represent that province in the legislative council of the Governor General of India. I hope this point is also clear. The legislative wing of council functioned as a mini parliament, as we see that the idea of parliament is to legislate laws. This legislative wing of the council is now acting as a legislative body, thus can be called as a mini parliament because number of members are very less. Legislation was treated as a special function of the government for the first time. It was till now the whole idea of the council was to just make laws and implement it. There was no demarcation between legislative function and executive function. Charter Act of 1853 made that distinction for the first time. It introduced an open competition system for selection and recruitment of civil servants. This again is an important point that in 1833, though an attempt was made, it never came about, never came to effect. But in Charter Act of 1853, what exactly do we see? It actually came to effect, and Indians can now be a part of the civil services. This again is very important because there is a confusion which a lot of students have that it was only from 1858 onwards that Britishers had opened recruitment of Indians in open competitive system. But now, what that point is wrong. Actually, it was in the Charter Act of 1853 when Britishers had already introduced induction of Indians in the selection of the civil servants, and there will be an open competition that will be held. Macaulay Committee was established. This committee was on Indian civil services and it was appointed in 1854. This again is very important both for your polity as well as for history. That Macaulay Committee, the purpose of that committee was to prepare the guidelines of establishment of Indian civil services, and it was appointed in 1854. There was an indication that company's rule could be terminated at any time in the parliament. So parliament was actually deliberating at that time that we essentially do not need company in order to run affairs in Indian territories, in the British territories in India. The whole idea was, if you actually see the progression, that it was company which came and was able to capture the territory. It was given full authority. Then after the Regulating Act of 1773, it was felt that we need to curtail the powers of the company. Thus, they were given only commercial powers and their political powers were taken away. Then it was felt even this commercial power is too much to the company and we should take away the commercial power. But it was felt that company still has a role in terms of implementing the economic policies. They were also given some veto power. Then, by Charter Act of 1853, what exactly was realized that the whole idea of company at this point of time seems redundant. We don't really need them. All we need is British civil servants to be operating the affairs, be it economic, be it political, be it administrative, with respect to the territories that are under possession of British government in India. It introduced local representation in the Central Legislative Council, a point that I just covered. Why? Because four members were appointed by the local governments of Madras, Bombay, Bengal, and Agra. So these members used to appoint their representative. This person used to go into the six-member Legislative Council, a wing, legislative wing of the Council of the Governor General of India. Thus, what we see local representation happening for the first time. Students, this is all we had for this lecture. We have studied all the constitutional developments that had happened till 1858. In our next module, we will be discussing all the developments that happened after 1858, right? For more such videos, please log on to Scholar. Thank you.